Good afternoon. Could you all take your seats, please?
Good to see you, friend.
Good afternoon. I'm Ginny Sloan, and I'm the president of the Constitution Project. As many of you know, the Constitution Project tackles a variety of important constitutional controversies by creating bipartisan consensus for important recommendations that we then distribute widely to policymakers, to the media, to the public. And one of the most important that we have tackled is this one, the death penalty. Today, our death penalty committee, co-chaired by Governor Mark White, Beth Wilkinson, who prosecuted Timothy McVeigh, the Oklahoma City bomber, and former Florida Chief Justice Gerald Cogan, is issuing its report and recommendations. And we think that you will find them very important and illuminating about this issue. Albert Camus, in Reflections on the Guillotine, said about the execution of one Burton Abbott, "Today, as yesterday, the chance of error remains. Tomorrow, another expert testimony will declare the innocence of some Abbott or other. But Abbott will be dead, scientifically dead, and the science that claims to prove innocence as well as guilt has not yet reached the point of resuscitating those it kills. If justice admits that it is frail, would it not be better for justice to be modest and to allow its judgment sufficient latitude so that a mistake can be corrected?" This statement was written in 1957, and it is just as relevant today as it was then, and it aptly captures the principles that guide the work of our Death Penalty Committee. Before we begin, I would like to welcome the many notable dignitaries who have joined us today, including a number from the diplomatic community in Washington. His Excellency Stephen C. Vassiani, Ambassador of Jamaica to the Organization of American States; Juan Silva, the United Nations Special Rapporteur on Torture; Robert Whiteman of the Delegation of the EU to the United States; and Analia Banfi of the Inter-American Commission on Human Rights. And of course, welcome to everyone else in the room. We also have with us U.S. diplomats from 13 countries from Latin America and 12 representatives from European Union countries. We're grateful for your interest in today's event and know how much these recommendations concern your countries and your citizens, as well as those of the United States. This afternoon, to guide us through the report, its recommendations, and its implications, we have a number of truly distinguished individuals. We're joined by Mark Earley, a Republican and former Attorney General of the Commonwealth of Virginia, who is also a member of our Death Penalty Committee. While he was Attorney General from 1998 until 2001, the Commonwealth carried out 36 executions. After leaving public office, General Earley became CEO of Prison Fellowship, and he's now in private practice in Leesburg, Virginia. We're also honored to have with us today Anthony Graves. Mr. Graves is the founder of Anthony Believes, a justice advocacy organization in Houston, Texas. Mr. Graves is the 139th person freed from death row after proving his innocence. He's the 12th exoneree from Texas. Mr. Graves fought for his innocence during his 18 years of imprisonment, 10 of which were in solitary. Remarkably, the state set 2 execution dates for him while he was on death row. Mr. Graves also recently established a scholarship in the name of the woman who helped clear his name. We also have with us by phone, because of a family emergency, Megan McCracken, who is an Eighth Amendment Resource Counsel at the University of California at Berkeley. There's probably no better expert on the Eighth Amendment implications of execution by lethal injection than Megan McCracken. Our discussion will be moderated by Nicole Sprinson, an attorney at Aiken Gump, Strauss, Hauer, and Feld. Not only are we grateful to Aiken for hosting us today, but we're grateful to Nikki and her team at Aiken, who have dedicated countless hours over the last 2 years to the research and drafting of the report that we released today. Thank you once again to Nikki, and also to my friend Julia Sullivan, who's here today, for your incredible commitment to this important initiative. Last, but certainly not least, I want to introduce the co-chair of our death penalty committee, the former Democratic governor of Texas, Mark White, who served as governor from 1983 through 1987, and during that time oversaw 19 executions. We're so grateful for his guidance through this process and for his being here today. Governor White.
Thank you, Virginia. I am delighted to be here. After that introduction, I'm not sure if I'm not the devil's advocate in this organization. What an illustrious group that was assembled. I'm just pleased to be part of it. General Early and I've just recounted some of the concerns that I had when I was Attorney General, as he has been. Also, it's good to be with Anthony Graves, who can speak with more particularity on the issues that we're talking about generally. I'm also honored to be part of the Aiken Gump organization here. Nikki, thank you for what you've done, what your great law firm has done. I feel very much persuaded that had Bob Strauss lived, he would have already solved this problem, and we would be on to another issue. Those of you not familiar with Bob Strauss, he, I might add, was from Texas, but he did spend a lot of time in Washington and was one of those who brought people together. This is an organization, the Constitution Project, has brought people together who come from diverse views on the death penalty. We have those who are strong advocates, which I had been, and also those who have strongly opposed it. In order to bring those groups together, we are today announcing the product of our work, Irreversible Era. It's a program in which it doesn't really bring out any moral judgment so much as points out things that need to be done and must be done in order to see that the death penalty, if administered, will be done fairly. Wrongful convictions, we're familiar with. This committee's been working for more than a decade, and now the result of that effort is before you today. We've had members of the committee that are judges. They've overseen criminal trials that included the death penalty, both in state and federal courts. They've had members who were prosecutors who have imposed the death sentence, carried out execution. We have members of a committee who were investigating the capital crimes for our enforcement agencies, others who've defended capital crimes. Some of our members who also have suffered as a result of those crimes and the victims of those brutal crimes themselves. As governor of Texas, I oversaw 19 executions, and I can tell you that there's no more gut-wrenching experience for, at least for me as governor, than to preside or have a part to play in those executions. I was very involved in it because, having previously been an attorney general and a lawyer, having also defended one person who was accused of capital murder, I was intimately familiar with the details of those prosecutions and also the frailties. I had been convinced that we were doing a good job and we were protecting the defendant, affording them all of the protections of the Constitution and the laws of our state. Over the years since that time, I am not so certain that we're doing a good job of that at all. This past week, the death penalty was thrust back into... Is it you hear too much or can't hear enough? Sometimes that's better. This past week, the death penalty was thrust back into the public debate as a attempted execution of Clayton Lockett in Oklahoma resulted in what has been called a botched execution. I don't think botched is the right word. I think that's one of the worst political cop-out words I've ever heard. That was gruesome, it was torture, it was inhumane, and it was wrong to the core. The fact that it broke down in Oklahoma only to be rejoiced on the part of our Texas governor in which he said that we'd never had that problem. That hope is true, but I hope it's not just a hope, because we never know until it's too late, and this procedure has not been well vetted. My fellow committee members are very concerned, deeply concerned over this process and the flaws that are within it. And since I've left the governor's mansion, I have seen that there is an abundance of unfairness and accuracy in which we go about this process. Texas, though, has made some reforms. We're doing a better job than we did in the past in giving support to the defense in rural parts of our state. By and large, though, we're seeing continuation of procedures across the nation that are outdated policies. They have not done anything to support the fairness of this procedure. The forensic problems that we have, I guess no greater example of how flawed it is the Houston, Texas Police Department ran the forensic testing there. We didn't have anything wrong with it, except we had leaks in the ceiling that contaminated the samples. We had people who were not qualified to do the testing, and they were also others who testified. You couldn't paint a picture of a worse situation than what we had there in Houston. Corrections have been made, but we failed to take one rule into account. We've known about those problems for years. And even after we acknowledged the problems, it's taken more than 4 years to take action to see that they're corrected. I remind people constantly that we fought and won World War II in less than 4 years. Seemingly, we could cure that rather simple problem in less time. Even our National Academy of Sciences have weighed in on the fact that our forensics at criminal justice level are flawed, and they are suggesting that action be taken. It's good to think about one statistic. Over 50% of the first 225 wrongful convictions that were overturned by DNA testing, over 50% of them, those convictions were based on science, forensic science. That was what it was called then. It's called junk science now. Supreme Court has declared, for instance, those people who are intellectually disabled from being given the death penalty. Today in Texas, we had the horrific circumstance, combination of events in which the state administered the test for IQ. The state administered their own test, and the defendant failed it by 7 or 8 points, only to have the prosecutor in a rural court stand up and inform the court that, oh, Judge, you know those people don't test well. Can you imagine in the 21st century we have that sort of comment going on in a criminal court in which the life of a person is being tested? The problem with that was we didn't get any judicial review because the federal courts have constrained our judicial review such that we don't get the use of the most important writ we have, writ of habeas corpus. This particular defendant had already used his writ. The fact that a lawyer may have abused the writ should not be a factor that condemns the person to whom it's to be used for protection from using it. That needs to be changed. Last week we saw the President of the United States appropriately speak to the need for a review of the death penalty in our country. I think that it could be nothing could be more timely than the issuance of our report today. And I think that Jenny and others have told me that that report will be afforded to the Attorney General, Eric Holder, and it is a good beginning, if not a beginning and an end, to the review that needs to be done to make significant changes in our criminal justice system affecting the death penalty. And for that reason, I'm very pleased to share this role with General Early as co-chair, and also to turn this podium over to him because he speaks more definitively to the issues because of his experience in Virginia, which is, I guess, second only to Texas and probably would exceed Texas if they just had more in the line of execution. But General Early speaks fluently on these issues, and he too was one of the leaders that brought about this remarkable study that's being given to you today. Thank you, General.
Well, thank you, Governor. It's been a privilege for me to serve on the Constitution Project's Death Penalty Committee, and as Governor White has said, I want to thank all of the folks on the committee that have done such tremendous work, and also the staff, President Jenny Sloan and Sarah Tuberville, who's a senior counsel, Nikki Sprinson, who's here with Aiken and Gump, who's done so much work, and the firm has offered their facility for more than this meeting, so we're really grateful. So it's a pleasure for me to join them, and Anthony Graves, who I'm going to introduce to you in a minute, whose story is really powerful. You know, I learned a long time ago that the way to illustrate sometimes complicated legal issues is to tell a story. And Anthony's going to tell you a story that I think sort of sums up why the Constitution Project's Death Penalty Committee has 39 recommendations for states across the United States to consider. So, Anthony, I really look forward to your comments in a few minutes. My comments will be brief. I just want to talk about 4 of the 39 recommendations that are coming from the committee. Just by way of background, I was in the Senate of Virginia for 10 years and then Attorney General of Virginia for 4, and then I ran for governor in 2001. I lost. I like to say I came in second, but it doesn't count in politics. But during the time I was in the Senate and Attorney General, I had a fairly, I think, cavalier approach to the death penalty. You know, conceptually it seemed right to me, and so I was a very strong advocate of the death penalty. As Attorney General, when we had 36 executions during the time, and it was only 3.5 years that I was there, it changed the way I looked at the death penalty. I looked at it a lot less conceptually, a lot less cavalierly, and I came to the conclusion that as someone who throughout my career had been a small government conservative, I wondered why I placed so much faith in the government to get perhaps the most ultimate decision any entity could make right. Now, why do we believe that the government can always get the death penalty right? And so we obviously know now that we can't. And the genesis for a lot of these reforms have been what we've seen throughout the United States over the last 2 decades in death penalty processes, and why we need to ensure that if we're going to have a death penalty, that it has to emphasize fairness and not expediency. So let me talk about 4 of the recommendations specifically. One is we need to have attorneys who represent defendants in death penalty cases to be experts at what they do. 50 years ago, last year, we had the Supreme Court case of Gideon versus Wainwright, which says that a defendant has a right to counsel. And we all know that people who are charged with a death penalty have the right to counsel. But if you're going to have heart surgery, you don't just want to write to a doctor. You want to write to a heart specialist who is well trained and is an expert in heart surgery. The same is true for the death penalty. You do not just want a lawyer. You do not just need a lawyer. You need someone who is well trained in death penalty defense. And it is a highly specialized area of the law, extremely complicated, infused today with so much science, so many procedural issues at the state and federal level. Many of our death penalty lawyers who take these cases and get appointed to them around the country are under-resourced, ill-equipped, and lack training. It shocks me now to look back, I don't know how many years ago, 1984. I was out of law school for 2 years. I was on the court-appointed list in Norfolk, Virginia, and was appointed to represent a young 22-year-old man who was charged with capital murder. At the time, I was privileged to have that opportunity. But that should have never happened. I didn't have any business handling a death penalty case because I had no experience in it, and yet this man's life was placed in my hands. It's another story how that turned out. I won't tell you it turned out fine, but not because of me. It turned out fine because I happened to know the lead homicide detective. He was a friend of the family. So we need to have well-equipped lawyers who represent death penalty defendants. States like Virginia, my home state, have made tremendous strides in this in the last few years in setting up a capital defender's office, well-trained investigators, well-trained lawyers, and most importantly, well-funded. It takes money to do this, and it has to be done at the state level. Texas, as Governor White said, has made a lot of strides. They have a specific public defender now, a specialized public defender for defendants in less populated counties where there's not that many lawyers. They have a statewide office of post-conviction review, which is vital. But what we're recommending in the report is that every state look at the level of competence of the lawyers that represent those in death penalty cases to set up an independent authority that can monitor, train, and resource these particular teams of men and women who do some of the most important legal work in the country. The second recommendation I want to talk about, and it's closely linked to the first, is that after the trial is over, if a defendant has had ineffective counsel, that the way that case is reviewed be changed. Right now, if you're able to prove that you had ineffective assistance of counsel that fell below a minimum level, that's not good enough. You then have to show that even though you had just a doctor and not a heart surgeon, that you would not have been found guilty. Well, that's a real high stair to climb. In this report, all of the committee and all of these recommendations are unanimous, suggest that the new standard be that if you show that you've had representation that falls below the minimum qualifications, the minimum standard of competency, that the burden then shifts to the state. It doesn't stay on you. It shifts to the state to show that the outcome would have been the same. The third recommendation I want to touch on briefly is that when there is a review of cases at the post-conviction level, and there almost always are, that the review be made on the merits of the case. Too often today, the judges never get to the merits of the case because the procedural issues trump them from getting there. I remember when I was Attorney General, almost on every appeal case, our biggest gun was that we're not even going to get to the merits, Judge, because the procedure wasn't followed. And if you win on that, then the judges don't get to see the merits. Right now in Florida, as example, 34 death row inmates will never have their cases reviewed under current law because their lawyers failed to file a review request required by federal law within a year. So it will never get to the merits because of a procedural issue. So we need to move these procedural issues out of the way a bit so it can get to the merits more, which at the end of the day is really, I think, what all Americans feel comfortable with. If they support the death penalty, they want to make sure it's based on the merits, not a technicality that keeps justice from being done. Finally, the last recommendation I'll touch on is the felony murder rule. The felony murder rule simply says if you're involved in a felony that results in a murder, even if you didn't pull the trigger or hit anybody, if you were part of the conspiracy or you drove the car or you pushed somebody down but you didn't intentionally mean them to be harmed, then you can be found guilty of murder. Well, in some cases, in some states, you can not only be found guilty of murder, but you can be found guilty of capital murder. If that's the case. There's an example in Tennessee, a fellow by the name of Carino Pruitt just to show you how I think unjust this application of law can be. He and his friend decided to steal a car from a convenience store parking lot. Car's owner, a 79-year-old man, came out of the store. Pruitt pushed him to the ground and drove away. No firearms, no weapons were used in committing the robbery. The victim, at 79 years old, had serious health problems, including a bleeding disorder, and he later died in the hospital. When Pruitt learned of the death, he turned himself into police. Not only was he found guilty of second-degree murder by a jury, which means the jury found he didn't intentionally cause the victim's death, but because Tennessee has a felony murder rule, he was found guilty of felony murder and was given the death penalty. So in light of that, this report, Irreversible Error, suggests strongly that the felony murder rule not be applied in death penalty cases. So I've just touched on 4 of the 39 recommendations that are in the report. We all feel strongly about all of them. It was a pleasure to serve alongside of these folks. And again, this committee and this report is not about being for the death penalty or against the death penalty. It is about saying if there is going to be a death penalty, if we're going to allow the government to take a person's life because of a crime, the trial process should be fair, and it shouldn't be a rush to expediency. At this time, it's my pleasure to introduce to you Anthony Graves, and I've already told you a little bit more about him. I'm not going to tell you more because I want you to hear his story. Anthony, come on up.
Wow, thank you. Sarah, thank you for inviting me. Governor White, General Early, thank you guys for allowing me to sit on the panel with you. In case you all didn't know, my name is Anthony Graves, and I'm a death row exoneree number 138. There are 12 more like me that was in Texas. I was 26 years old when I was arrested and charged with capital murder. 2 years later, I was found guilty and sentenced to death by lethal injection. I turned 45 when I was exonerated. 18 and a half years. And I witnessed some of the worst inhumanity that any man can witness. And I have to live with it every day. Conditions on death row were horrible. I seen guys hang themselves, guys slit their wrists, guys overdosing on their medication, guys dropping their pills. Not so much because they was guilty of what they was being charged with, but the conditions. The conditions were unbearable. When I first got out, I had to make this transition back into society. They took me from solitary confinement and put me right on the streets. No transition. Okay. I was just lucky that for some reason I was sane. Not so many of them come out like that. At least not like I did. This capital punishment that we're talking about, I don't care how many rules we make up, how close to getting it right we think we are. We're never, ever going to stop killing innocent people as long as we have the death penalty. There's just no way. I mean, this here, I say that if this had been in place before when I had went to trial, I would not have probably went to death row. Okay? Because if they would have practiced these rules, I wouldn't have went. But I don't always think that it is just the word on paper that we got wrong. It is the people we're entrusting that we're getting it wrong. We're their bosses. And we're hiring the wrong people. So as their boss, we need to start hiring people that really cares about seeking justice. In Texas, we have this motto, tough on crime. I think it just changed the whole landscape of our criminal justice system because it gave them a green light to take shortcuts to get a conviction. I know this. I walked into a courtroom full of hope because in my years of learning in school, I was told that we had the best criminal justice system in the world. So for the first 2 years that they had me incarcerated, just holding me, I kept begging them, please take me to trial. Because from what I know, that all I need to do is get to trial, let the truth come out, and I go home. Unfortunately, that's just not the way it works. That's not the way it works because we're tough on crime in Texas. Okay? We have the green light to do what we want to do to get a conviction. And then we have an appeal court that will rubber stamp it for us. Okay? That's the truth. That's my truth. This is not in here. This is my truth. I watched our system fall from top to bottom. From the initial arrest to my conviction, to my exoneration, to going back to jail, well, the reversal, going back to jail for 4.5 more years before I was finally exonerated. I watched the system try to cover up their mistake. They kept coming to me after the case was reversed, asking me to take a deal. Would he take a life sentence? What would he take? And I had to tell them, you kill me or you free me, because I'm not going to compromise the truth. And therefore, I stayed for a little over 4 more years in solitary confinement in the local jail, trying to break my will. But see, I'm here today because I'm a voice for the voiceless. I watched those men. I read their cases. It's horrible. Guys are down there simply because they couldn't afford justice. That's it. The worst of the worst is not there. It is those who could not afford justice. Unfortunately, a lot of them look like me. It's because I couldn't afford justice. I came from the projects. Okay? I believed in the law. I was a law-abiding citizen, but I didn't have the resources. So when they came and knocked on my door and told me that they was taking me downtown to be interrogated, I cooperated 110%. The chief ranger got on the witness stand and told them this man cooperated with us 110%. They still denied me a bond. They had no evidence on me. The judge still said bail denied. They said, well, is there anything that this man, that y'all have on this man that connects him to the case? The chief ranger said no. The judge said denied bail. I seen the system fall from top to bottom. Prosecutor accountability is my strong thing. It is my pet peeve because I think they are the ones that drive our system. I'm not out to bash prosecutors. I'm for good prosecutors. I just want to weed out the bad ones so that we can start seeking justice again, because that's what it's about. I'm not here to say, hey, we need to free everybody on death row, because I met guys that I wouldn't want to live in my neighborhood. I am here to say that we need to make this system fair. Fair for all. If we're going to practice the death penalty, know who we execute. Most of us don't even know their names until they're in the paper. But we've been supporting the whole notion of executing it because we have the death penalty. You have to get involved. You cannot do this from the sideline anymore. Too much is at stake. I watch little kids come down there, 17 years old. There was a young guy named Napoleon Beasley that came to death row. His crime was when he was 16. He killed a federal judge's dad. First time in his life he ever done something wrong that we know of. But this kid was a valedictorian. He was great in sports. And he made one mistake for 5 minutes in his life. And I watched this kid come down there at the age of 18, 17. So remorseful. He spent his time writing letters to young kids in reformatory schools, sharing his story with them, pleading with them not to go down the wrong path. And it wasn't good enough for Texas. We still executed this young kid whose mind hadn't even matured yet, wasn't even fully developed. But we took one act out of his 17 years of living, and we murdered him. And that's what I call it. Let's get to the heart of it. We are murdering people. Execution is just a nice way of saying it. We are murdering innocent people, people who are mentally ill, people whose cases didn't even deserve a death penalty but couldn't afford the resources. Those are people we're killing. And they look like me. And they look like Latinos. Those are the people we're killing. But had we had this in place, the makeup would look totally different. There wouldn't be a lot of people on death row. It just simply would not be. Because this would have been a stopgap. We have to take this serious. If we're really talking about being fair and equal, then we have to take this serious. Because I am telling you, there are guys down there who are counting on me to let you know that they're innocent back there. Not all of them, but there are a few. And if I don't get it across to you guys, to let you know that this book is needed, it should be adopted in our legal system. Because if not, those guys who are counting on me are going to say I let them down. Because they're going to be executed. And it's going to be on our hands. Because as I said when I first came up, we are the bosses. We elect. We select. We have to take our role more serious. We just cannot be putting somebody in office because they have a name that sounds good when their policies does not match ours. 18 and a half years, over 350 executions I witnessed. Guys I was able to talk to 12 hours before they were executed. Looked me in my face with tears in their eyes. This is a grown man telling me, I didn't do this. I didn't do this. But he was executed. He was executed anyway. This one guy I'm talking about, his case was reversed. He had a reversal for 2 years. This man was ready to go home. He was happy. He felt that justice had finally prevailed. His name was Charles Bard. They took back his reversal and executed this man. And on his way to the gurney, he was crying, I didn't do this. That's what we have going on in our system. A system without this. I had 3 kids when this happened to me. One of my sons had sickle cell anemia. And every time we would have to take him to the hospital for a blood transfusion, I would be there. I would spend nights with him at the hospital. So when they convicted me, my son testified. I need my daddy. My daddy is my strength. It fell on deaf ears. My son now is legally blind. He had a stroke while I was away, fighting for my life. So he had short-term memory loss. And I should have been there with him. I could never get that back. And that's what happens when we get it wrong. We take things that no one can ever give back. I am saying, help us. Help those down there that are innocent. And adopt this. Adopt this. Make sure that these things get into our system so that we can start protecting innocent lives. Thank you.
Thank you, Anthony, for your comments. We truly appreciate you sharing your story with us. And I think there's no doubt, if I can hold it together, that was the most powerful moment of the day that we'll have. And now, at this point, we'd like to spend a little time talking amongst ourselves here up at the panel, and also with Meg McCracken, who we have on the phone. Meg, can you hear us effectively?
Yes, I can. Thank you.
Okay, great. And actually, Meg, we'll start out with you because what I'd like to do is talk about some of the other issues that the report touches on. Certainly, we can't be exhaustive in the time that we have because we've covered a lot of material in the report. But I'd like to bring out some of the other topics and see if we can get your thoughts on all of them. And I'll remind all of the panelists that if you want to speak, you need to actually push the button so that your light turns green so that we can all hear you. So, Meg, the topic I'd like to start with during our panel discussion is a topic that many people think of when they think of the death penalty, and it's one that's been in the news this month, certainly, and that's lethal injection. Meg, can you tell us a little about what happened last week during the Lockett execution in Oklahoma, which, as I think everybody in this room knows, went terribly awry?
Sure. I think that there were several factors at play in Mr. Lockett's execution, in the lead up to his execution. Can people hear me?
Yes.
Okay. There was a rush to execute both Clayton Lockett and Charles Warner, who was scheduled to be executed 2 hours after Mr. Lockett. There was a rush to execute with the state's new protocol, using a new drug formula that used 3 drugs at doses that had never been used before in an execution. There was an intense legal battle and political pressure on the Oklahoma Supreme Court to say that it's okay to move forward with an execution where the procedures are shrouded in secrecy and the necessary information about the drugs has not been revealed. There was an execution team unprepared and incompetent to perform the tasks assigned to them. And then, as I said before, there was secrecy regarding the pertinent information about the drugs to be used. What are these drugs specifically and who made them? And so Mr. Lockett's horrific execution was the predictable and foreseeable consequence of the state's rush to execute without transparency and without an execution team that was qualified and competent to perform the procedures appropriately. The information continues to slowly come out of Oklahoma, and so we now know that Mr. Lockett had one IV set in his femoral, well, not set, but intended to be set in his femoral vein, which is in the groin. It appears that that IV was not actually in the vein, meaning that the drugs were not delivered into his circulatory system, but likely into his flesh. I'm saying words like likely and it seems like because, of course, we don't know. The information is not out, and so unless and until there is a thorough, transparent, and truly independent investigation of what happened at Mr. Lockett's execution, we cannot say with any certainty at all what really happened. I can say what appeared to happen, and that is that the drugs did not go into Mr. Lockett's circulation, but rather into his flesh, and therefore were absorbed very slowly. He remained conscious long after it would have been expected that he would be unconscious and unaware. And then the state closed the curtain. And so the witnesses were not able to see what was happening, and 27 minutes later, they were informed that Mr. Lockett had died.
All right, and Meg, there's some related issues, one of which you touched on during your answer just now, which was the issue of secrecy that surrounds the access to many of these drugs. And there's also the issue of where we actually get the drugs from that are used during executions. Can you talk a bit now about the current controversy surrounding both of those issues and how they play into lethal injection procedures that the states are carrying out right now?
Sure. So unlike maybe 10 years ago, even 5 years ago, right now what we see happening across the country is that states are carrying out executions in ways that differ from one another. They're changing their protocols using new drug combinations at different doses. Whereas we used to see that every state used a 3-drug protocol, there were differences between them, but they all used the same 3 drugs, just at varying doses. Today, we have states with 1-drug protocols, 2-drug protocols, and 3-drug protocols. And then within those, they're using different drugs at different doses. So there's just a lot. It's a very dynamic and shifting landscape. At the same time that states are using novel and experimental drug formulas, they are also increasing the secrecy surrounding their procedures, particularly secrecy surrounding their drug sources and what the drugs really are. In the report, Debbie Deno identified intensified efforts on the parts of the states to obscure information regarding the development and implementation of their protocols, and that's exactly right. Several states are using compounded drugs. These are drugs that are made to order and mixed from raw ingredients by a compounding pharmacy. These drugs are not FDA approved, and although they certainly meet a crucial need in medical care, using them in execution unnecessarily brings risks of pain and suffering to the process because there is no guarantee of what's in the syringe. Other states are using new combinations of drugs, and I am so sorry, everyone. I'm going to put this on mute because here's my child trying to talk to me.
Yeah, I think so. Okay. Meg, if you can hear us and you're able to come back, please join us. We'll just turn the panel right now to talk about another topic for the moment, which, Mark Early, you had commented upon this during your opening remarks, but isn't the crux of many of the problems in the context of handling capital cases the inequity between the available resources between the prosecution and the defense?
Yes, it is. There's a tremendous, historically, a tremendous inequity in resources. You know, the prosecutors, they don't always have all the resources they would like, but the fact is they have far more resources historically than the defendant lawyers for capital murder cases. It's getting better now as states make needed reforms and fund death penalty centers in the states, train lawyers, provide money for investigators, provide money for the defense team to do the kind of hiring of experts that they need to do. But it's still amazing in court-appointed cases in general and in death penalty cases how much you have to fight to get the court oftentimes to approve resources for you to defend your client. So, and certainly when a life is at stake, there ought to be a level playing field between the prosecution and the defense. So that's why one of the recommendations is, not only to train and have very well equipped defense teams to represent those charged with capital murder, but to have them well funded and well resourced as well.
Mm-hmm. And Mark, you also spoke in your comments about what's the Strickland standard, so the test for defendants to be able to show that they had ineffective assistance of counsel and the high burden that imposes on defendants in their struggle in order to make that showing. What kinds of problems does that practically mean for defendants under the current standard that we have?
Well, what it practically means is, you think you might have given yourself a shot at the merits if you show that you had a lawyer that didn't rise to minimum competency standards. And in some of these cases, that's putting it very nicely. Some of them, the representation was just truly abysmal. But then to have to show that even if you had competent counsel, there is a reasonable likelihood that you would have been found not guilty is very difficult to do without getting your case before a judge to talk about those very merits. You have to show it on paper initially, and that's very hard to do because you're pretty much stuck with what was there at the trial. It makes it difficult to get to new evidence. In Virginia, when I was Attorney General, we had a 21-day rule, and if you didn't get in new evidence after 21 days of the judgment, you had to fight like crazy. It was just really, really difficult. So to put that sort of burden on someone, we just think the burden ought to shift to the state. If the defendant who's been convicted of capital murder and now faces losing his life has shown that he had incompetent counsel, then at that point the burden ought to be off him or her, and the state should have to show that even with that incompetent counsel, they would have gotten the same result.
And how do these attorney competence issues play out in the context of defense counsel's decision to offer or not to offer mitigating evidence? So evidence of characteristics that would counsel a jury against recommending or issuing a sentence of death.
Well, I think the point you bring up is, obviously most people in this room, I'm sure, fairly understand the legal system pretty well, but, a lot of lay people, when they look at a death penalty case, they think, okay, he's been, found guilty of the crime. Now it's pretty much over, and the jury's just going to decide whether he gets the death penalty. Well, that next stage, that bifurcated part of the trial that is all about now deciding, all right, he or she is guilty, should they get the death penalty, is as technical and as important, and the life hangs in the balance just much in that part of the trial as it did in the first part, if not more so. And so, the ability of an attorney to be skilled in presenting evidence about that individual's background, about their mental capacity, about, all the things that could mitigate in the mind of the jurors the necessity of the death penalty is not just something you sort of come in cavalierly and talk about. It is a very nuanced, technical area of the law that requires a lot of training and experience as well. So it just highlights the need and highlights the fact that these cases are highly technical, highly involved, and, they're not for laymen. I mentioned I got appointed on a case when I was 2 years out of law school. Thank God that case never went to trial. We were able to just provide the detectives with evidence they had the wrong guy, and they bought it. Well, that doesn't happen very often. But can you imagine me 2 years out of law school jumping into that sort of thing? I should have never been appointed. I should have never taken the case. We need people who are highly trained. This is what they do. They're the heart specialists of their careers.
And Anthony, I don't want to put you on the spot here, but I'll put you on the spot, which is certainly, I know you've seen a lot of cases with these issues. You've talked to a lot of people who've had issues like this, competency issues, ineffective assistance of counsel issues in their cases. So to the extent that you have comments about what we can do better, we'd certainly like to hear your thoughts as well.
Well, what we can do better, I think that, first of all, we're not going to get where we need to go until we change our attitudes toward this thing. Okay? I think that's the first thing. We need to understand that because what this man done may have emotionally traumatized us, that's not where we get our verdict from. It should be a rational thinking process. Okay? We don't have that. We have an emotional thinking process. Prosecutors get up, sell their story to the jury, tap into their emotions, and get a conviction. Nobody's heard about the facts anymore. I think a big problem that we have is we don't have an educated juror sitting up there. I think when it comes to capital cases, what we should be doing once we sit a jury is we should be giving them at least 3 to 5 hours of training on what their job requirement is. We get 12 people off the street, and we go in there, and they don't even know about the system. Most time when they come off the street, like you're talking about a layman. And we go in there, and we ask them to make the most important decision in that courtroom. Yet they were the most uninformed. They don't know anything about suppression of evidence. See, they don't know how, when a judge sustains or overrules, how much of an impact it has on the outcome. They're caught up in their emotions because a prosecutor has sold them this story, even cried to them. And it takes away from the facts of the case. So we have to get back to this whole attitude of seeking justice, regardless of what side you're on. When a man walks in that courtroom, he should be innocent unless proven guilty, not until. That's the setup. because you're saying we're going to get there eventually. He should be innocent unless proven guilty. That should be changed in our law. So I just think the reforms start at the initial stage of the case. The arrest, that should be guidelines. That should be this here videotaping and audio. I'm telling you, this is needed. Because a lot of times what happens is when you get a recorded conversation, usually it's a confession. Why? Because before he confessed, he was tortured. Okay, he was told that he's a murderer and that he would never go home. Okay, and then they got him to where he said, okay, well then if you just tell us, we'll let you go or we'll help you. And then you get the recorded part. Oh yeah, I did it, da da da.
And just for a point of reference, you're talking about the report recommendation that
yes, I'm talking about the report
all interrogations be
video,
recorded,
yes,
preferably audio and video recording, and from start to finish,
and
not
from
just
start
the admission
finish.
part.
Yes, exactly. And look, with me, I just started my foundation, and it's geared to what Mr. Early was talking about, providing resources to independent defense counsels to help support them. Because when you look at it, you have a state that it has so many entities to help support them. FBI, Texas Rangers in Texas, and on and on. And then you look on the other side of the table, and you got this overwhelmed, overworked, underpaid, indigent defender representing this young man with no resources. You're not going to get to justice. We're not going to get a fair trial in that setting because, number one, this guy can't even defend himself. He don't have the resources, and his attorney is so overworked and being pressured by a judge to move his cases along that our system has now sort of been set up to plea bargain. That's where we at now. We at let's make them plea bargain. I just think that we just gotten away from wanting the system to be fair for all, and we're about trying to convict someone now, and that's a big problem.
All right. I understand that Meg is back on with us. Can you hear me okay, Meg?
Yes, I can.
Okay, great.
I apologize for the disruption.
That's all right. I just wanted to follow up on some of the points that you were making about the access to information about the source of drugs and the makeup of the drugs. How do we fix those issues? How do we help resolve them? I mean, what's the answer to trying to get transparency on those topics? And from a legal perspective, I know you've done a lot of work in the Eighth Amendment area. Has there been much success in that regard? What kinds of efforts are being made?
Sure. So, just of course, we're referring to Recommendation 37 from the report. Jurisdictions should act with transparency in the development and administration of lethal injection protocols. What we are seeing at this moment when states are changing their protocols using new drugs and new combinations of drugs is a simultaneous intensification of the secrecy surrounding the procedures. And so, in addition to the identity of the execution team members, which is appropriate information to make confidential, they are also making confidential the source of the drug, which could, in the end, hide what the drugs really are. So when some states are using manufactured FDA-approved drugs, other states are using compounded drugs, which are not FDA-approved. And so what is at stake here is knowledge of what the procedure really entails and whether or not the drugs will work as intended. It's crucial to know what is in the syringe at the time of the execution, and you simply cannot know what that drug is, what the product is, and whether it will work as intended unless it has FDA approval. In terms of the court's view of these issues, we see a mixed bag. So in the state of Georgia, where the secrecy statute goes a step farther than others and makes the information about the sourcing of the drugs a state secret, meaning that the court cannot see the information, the trial court took exception to that statute, declared it unconstitutional under the state constitution, and that decision is on appeal. It's been argued in front of the Georgia Supreme Court. We're waiting decision on that case. Similarly, in Oklahoma, the state trial court found the secrecy statute, which was challenged prior to Mr. Lockett's execution, to violate the state constitution. The Oklahoma Supreme Court eventually postponed Mr. Lockett and Mr. Warner's executions in order to take a close look at that decision on appeal. But then the intense political pressure from the governor and from the assembly in Oklahoma came down hard on the Oklahoma Supreme Court. There was talk of impeaching the justices who had voted for stays of execution in order to review the decision that the secrecy statute violated the state constitution. And shortly after the political pressure ratcheted up, the Oklahoma Supreme Court reversed course, decided the case in 48 hours, and allowed the executions to move forward. And as Governor White spoke so eloquently about before, we see what the consequences of that decision, what they were.
And Governor White, that's a natural segue to you, and just so you know, let me turn that on for you.
Thanks.
I think we all have probably seen that as a result of the awry Lockett execution last week, that the Oklahoma Department of Corrections director called for an indefinite stay of executions until the state changed its execution procedures and staff were retrained. Initially, the governor of Oklahoma stated that she would have a complete review of the state's execution procedures conducted. But I saw an article yesterday where she stated that justice was served and the people of Oklahoma do not have blood on their hands. In how much, in your assessment, do politics play into this? And is there a place for politics here in capital punishment?
Yeah, I'm afraid to say politics plays a major role in it. I regretted one of the spots that I put on television sometime after I'd left the governor's office in an effort to regain it. Was in poor taste, to say the least. And the pressure on these people is enormous. But yet that's where leadership, I guess the best way to put it, that's really what leadership's all about. It's pretty easy to let the crowd determine the direction that you go or one goes, when in fact the importance is to stand up and say, and we've seen governors who've done it. Governor Richardson in New Mexico presided over the repeal of the death penalty in their state. And at some stage, I think, when the facts are known, the people in this country will say, there's no way that you can have the assurances that you need to have to be certain that this person should be executed, as was just pointed out by Anthony, that right now we're little better than a trip to Las Vegas on getting this thing right, and that's not very good. Everything you see in this report, if implemented, still doesn't get you to where you have the certainty that we're right. And as a result of that, for those people who claim they don't want government involved, they want too much government involved, we've got to rush to justice. What's more important than the life of an innocent person? That's the ultimate importance. That's of the ultimate importance in a free society. And to jeopardize or to place in jeopardy that person's life because we didn't get it right, getting it right is much tougher than I ever thought it would be. Cool reflection, and that's what this has been, evidence of the result of lots of cool reflection, points out the past discrepancies. What I thought was a certainty was not certain after all. What we all believed in before, that eyewitnesses were the best witness you could possibly have, oftentimes just the most flawed witness you could have. The tests that we thought were certain about whether this was a arson or not, just absolute flip of the coin. Fact is, wasn't even flip of the coin. You were always wrong. if you claimed it was arson based on what they were presenting as the evidence of arson. That was zero. That had zero impact on whether, or on the question of whether it was arson or not. We've been so horribly wrong in the past when we thought we were certain. Even by passing everything we suggest here, we will then think we're certain? No. And that's what Anthony's talking about. And that's what I think America needs to hear, is this is such a fragile process that just getting it right for punishment is a tough enough deal. And then going to the death penalty, my thoughts on this have changed dramatically over the years, and this has focused most of my change right here.
And Governor, we heard during Ginny Sloan's introductory comments that there's a sizable portion of the audience that represents other countries as well. How do we square the continuing use of the death penalty in a majority of states in this country when virtually every developed or developing country has, put it by the wayside?
Well, those people who decry Sharia law and they decry all of this uncivilized approach to justice looks to where they do many of the executions, they're right there. And just by guilt by association, is that what we want? How do we compare ourselves as a country? Which side do you want to be on? We're far better off. And let me wait just a minute. What he said, nobody heard. Nobody heard the real cruel punishment that's there in solitary confinement. How many people decided they'd rather die than go forward with that? That is cruel. That is tough. Solitary confinement in the state of Texas or anywhere else is a very cruel punishment. And we have people that sit there for years in solitary confinement in our state because that's the way it's gone. That's not a good system either. We're in very weak standing, I think, on the business of Eighth Amendment protections when you talk about ADSEG.
Yes, sir.
Man, this is as tough as it gets. You don't get a lunch. You get served lunch, but you don't get a lunch, do you?
You might have rat feces in it. You might have a roach in it.
Explain to them what the food is. Do they still give you that?
They give us dehydrated food. They put it in a hot box and let it sit out there for hours while they do whatever they want to do. And then when they decide to serve you, they serve it to you while your food is dried out. It's a little of nothing. All the produce come from, they grow it themselves. You don't get any kind of real meat. You just get some synthetic whatever. But you're never going to get a good meal down there. All you're going to get is hell. That's it.
Do they give you the food that comes through the blender or just all packaging?
Some of them, they call it a food loaf. Yeah, and they give it to the guys in solitary. They give them a food loaf. What they do is they take everything that they made throughout their day, put it all together, bread, milk, everything, and then they'll bake it. It's a food loaf, and then they'll go and give it to the inmate, and that's his meal. And it's no telling what's in there.
Well, that's maybe the next inquiry that this organization ought to have is exactly where you go. If you don't have a death penalty, what's the next step? What we're doing today, as Anthony points out, is a very rough procedure. I mean, it makes waterboarding look like he's just getting your sinuses cleaned out.
Yes, sir. You're right. You're absolutely right.
Can I just follow up on a couple of things, not the menu items, because it sounds like my cooking. But anyway, two things. One on the fact that the U.S. has the death penalty and has felt somewhat, I think self-righteous about it, and other countries have let it go. One thing I'll say about that, and it's not so much in defense of the U.S. as much as it is, I think, maybe understanding. I think most Americans feel like America has the best criminal justice system in the world. I mean, if you're going to be... We have so many rights here that are not prevalent in other countries, and I don't take anything away from the representatives of other countries here today, but Americans feel like they have a great system of justice, even though it's flawed. I think because of that, they've had an undue confidence in the fact that the death penalty, as part of that system, was also solid, that the way it's administered. I think what's happened over the last 20 years is I think more and more people, both those in the criminal justice system and those lay people on the outside looking in, realize this administration of the death penalty is a whole different can of worms. It is very complicated. There are many, it's not what it always seems. And so I think they've realized, well, yeah, we may have one of the best criminal justice systems in the world, but on this particular area, we either need a lot of reforms and need them quick, or we need to set this aside like other countries have done. But I think in part of it, I know for me, you just, you feel so confident about the U.S. criminal justice system that it makes you feel confident about this part of it too. But then when you get involved in it, you see, oh my goodness, there's so many inequities. There's so many places where due process falls apart. Politics does come into it in ways that are embarrassing at times. So I do think that's part of the mental makeup that have had us hold on to it. The other thing I wanted to mention that I forgot a minute ago about well-trained counsel for defense attorneys. If you look at the states, and Virginia is an example of this, that have recently increased the emphasis on making sure that the playing field was level and that defense lawyers were well trained, that if you got a death penalty lawyer that was appointed, this is all they do. They're well trained, they're well equipped, they are specialists. The number of death penalty cases have dropped dramatically. In Virginia, they've just dropped really dramatically. And part of that is because now those charged with the death penalty do have good representation. And so different results tend to occur. It's not always exoneration or acquittal, but it's often not the death penalty.
And Mark and Anthony, I want to pick up on a topic that you both have touched on in your comments and in question answers, and that's this issue of race and ethnic disparity, because I think we'd be remiss if we don't touch upon that in our comments on the panel here today. And so, Mark, I'll ask you to start in terms of how racial and ethnic disparity are factors into charging in prosecutors' offices, or does it? And what effect does it have on sentences that we're seeing that are death sentences? Related to that, I think it's also important to talk about proportionality review, which is the report spends some time talking about proportionality review, which is not just race and ethnic disparity, but also comparing a particular crime in one case with a particular crime in another case, same factual scenario in two different jurisdictions or the same jurisdiction, and are the same charges being meted out? Are they resulting in the same sentence? So, Mark, based on your experience as former Attorney General, can you comment upon those issues?
Well, actually, I'm going to toss the proportionality issue back to you because you know so much more about this than I do. But I'll comment about the race issue. And simply, I just will put it this way. Any inequality, discrimination that you have in society at large comes into the door of the justice system. Mm-hmm. It just does. It's the justice system is not some isolated place from the things that bedevil us in society as a whole. So for anyone who doesn't think that historically, in a hugely significant way, and even now today exists, decisions that are made based on people being in poor economic conditions, their race, their ethnicity. I mean, if it's in society, it seeps into the criminal justice system, and it doesn't just seep. I mean, it's there because the criminal justice system reflects the larger, problems that we as a society have. So, I mean, we had a jurisdiction in Virginia, that was just embarrassing for a long time. It was the Danville area of Virginia, and the prosecutions there of death penalty were so racially egregious that it was like you couldn't suggest that it didn't exist. It was like an 18-wheeler coming down the highway at you when you looked at the statistics. So it's there. There's a lot more focus on it now than there was 20, 30, 40 years ago, but it's still there.
All right. We have barely touched on the topics that the report covers, and I urge you all to take a look at it, certainly. But we want to open it up now for any comments or questions that the audience may have for our group of panelists.
I want to thank the Constitution Project for this wonderful report. I'm Robert Whiteman. I am on the staff of the European Union delegation to the United States, and so I have several colleagues from other member states of the European Union here, from other embassies as well. But I have two questions. As you can tell from my accent, I'm not a European. I am a resident of 30 years of the state of Virginia. But my first question is to Governor White. There's a man who's scheduled in Texas on the 13th of this month, Mr. Campbell, who apparently has some mental inabilities that would fall under the category outlined by the Atkins case by the Supreme Court. The system in Texas seems to prevent a rational consideration of additional evidence at the very last stage. The role of the governor seems very limited, and the Texas Board of Pardons and Parole seem almost inured to any new information whatsoever or anyone else's opinion. I would just like to raise that as an example for you of the difficulty I have when we get letters from your successors. We have stacks of them, and the results have not been very good. So that's really a comment, not a question. But
well,
I think the fact that the Supreme Court of the state of Oklahoma could change its mind due to political pressure in less than 48 hours should terrify every American in this room. This isn't a question of just one man's guilt or innocence or a process. This is a fundamental operation of our Constitution. I mean, this is really, to me, a very terrifying lesson, and hopefully more Americans will find out about this. And I've forgotten my second question for Mr. Early, so he's off the.
I thought you, being from Virginia, you'd ask him that question.
We like to pick on Texas.
I noticed.
It's so big.
I think our current governor has found out, at least to some degree, that as much as we may love Texas, very few other people love it as much. But let me say the reason we have it set up the way it is because we had a former governor named Paul Ferguson who was selling pardons, which was another way to get out if you had enough money. And as a result, they created the Board of Pardons and Paroles, which said the governor can't do anything without the recommendation of the Board of Pardons and Paroles. Of course, the governor appoints the Board of Pardons and Paroles. And you can see the history of that is that, and I must confess, they will generally do what the governor asks them to do. And so that's kind of one of those deals where you can hide the ball. This question you raised over mental retardation or mental competency, I don't know the latest code word for that, but
I think the report uses intellectual disability, which is the emerging trend.
Which is a much broader thing than mental retardation, in my view. Say it again, what did you call it?
Intellectual disability.
Intellectual disability. Woo!
Unfortunately, I'll tell you, the Supreme Court still uses the term mental retardation. So in the discourse, there's been some change, but not in the case law.
Well, anyway, that's also constrained by federal procedures, which we did not get hearings in the federal court because a prior use of the federal writ had been exhausted on a fellow who had failed the Texas mental retardation test administered by the state, as I described earlier. I don't make any. I'm not here to make apologies for it. It's certainly an error, It's something that needs to be changed. I doubt that we've changed. I don't think we've changed the law since the case, which speaks on the Supreme Court case. What is the Adams case on the
Atkins case?
Yeah, and so I'm not sure we've done anything there except try to avoid it. That's a mistake. I'm sorry. I hope that's.
Although the report does make recommendations in that regard.
It does.
So if we're looking to change that, those recommendations are in there. I think we have time for one more formal question, and then some of us may still be here for a little while if people have additional questions. Go ahead.
My question's for General Early. You made the comment that the U.S. had, in your view, the best criminal justice system in the world. And I'm wondering on what basis you make that, considering the fact that we imprison more people per capita than any other place in the world, despite our touted rights.
Yeah, that's a really good point. I spent 10 years after I got out of politics as the president of Prison Fellowship, which is a international organization that works with prisoners and their families. And we were very involved in public policy issues of trying to reduce the mass incarceration that's occurred in the country. So you make a good point. I mean, I think we, perhaps like on the death penalty issues, we have maybe a bit of a naive sense that it's the best in the country. I mean, I'd still rather be charged with a crime here than anywhere else. And I've traveled in a lot of places, and I've been to prisons all over the world. But the fact of the matter is we do incarcerate too many people for nonviolent crimes, and that should change pretty dramatically and rapidly. So, yeah. So, great point. Touche. I agree with you.
All right. With that, I thank you all for coming. I thank our panelists for being here, sharing their comments and thoughts with us, and, of course, the Constitution Project for just their fantastic work.
Good. Great job.